Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. I will be with you for the duration of the next hour, answering your questions in relation to any legal issues that you have arising. You can participate in this show in two manners, either by calling the studio live and speaking to me and putting your questions to me that way. Alternatively, if you prefer not to speak to me live in the studio, then you may still wish to submit your question, and you can do that through the mobile number you see at the bottom of the screen. Please do send your questions through as early as possible to allow me to read through them and get to your answers. Any questions sent later in the show, unfortunately, I may not have time to get through them today for you. Any questions that you do send through, please try and have as much information as possible to allow me to understand the key issues in the case so that I can provide tailored answers and to provide you with the best guidance as I am able to do so. If there are any further questions that I have, any supplementary questions, then I will ask them. And if you want to respond, again, either by ringing through on the landline number or by sending them through to the mobile number, I will pick them up. So in terms of areas of law that I can deal with, this is a general advice show. So any legal issues relating to either English or Welsh law, that's the jurisdiction that I practice in. Any other jurisdictions, unfortunately, I'm not authorised to practice in and may not be able to provide you with assistance. So to try and limit your questions to our jurisdiction. In terms of the areas, you've got employment law, criminal law, family law, immigration law, and there may be other questions that you may wish to ask, welfare benefits, etc., that you might want to send through. So feel free to do that. Likewise, I'm often asked whether the questions need to be in English. If you prefer to send your questions through in the Urdu language, again, please feel free to do that. And I will read those out for you and respond in Urdu and translate for our viewers who don't speak Urdu or understand Urdu. So moving on to the questions that I have this evening. The first question is, my husband has secretly remarried for a second time in Pakistan. In the UK, we have a joint mortgage. I wanted to find out if he leaves me and returns to Pakistan, what can I do for him to still keep on paying the mortgage? He is on the mortgage and title deeds. We have 2 teenage children. Then how can I make sure he pays maintenance from abroad as well? Thank you. So thank you for sending that question through. So our sister is asking in relation to her marriage. Her husband has a second wife, and her concern is that with their joint financial liabilities in the United Kingdom, what would happen in respect of those if her husband left the UK and emigrated and set up his new life in Pakistan. The difficulty that you have, sister, is that the mortgage, even though you are jointly named on there, you are likely to be jointly and severably liable. And essentially what that means is the bank can require either party or both of you to pay. But if your husband leaves the United Kingdom, it's difficult for the bank to enforce his side of the contract. So it's difficult for them to force him to pay when he's not within the UK jurisdiction. If you are then left here, the easier option for the bank is to pursue you for those payments, to hold you liable for the full amount that's outstanding. And so that would be your difficulty. The bank wouldn't then think, well, just because he's in Pakistan, we will pursue him as well. And so you would be required to keep up those payments, and any default would be registered against you, and any legal action essentially could be taken against you as well. And again, maintenance is a difficult one, because if an individual is outside of the jurisdiction, then enforcing those kind of agreements can be quite difficult. Certainly, if you have a contract in place, then you may wish to enforce that through the UK courts, and they may then write to him. If there is no contract, you would find that a lot more difficult. So that's unfortunately the response, that you are liable, and that there are limited legal options that you have to enforce those rights and options if your husband emigrates and sets up life in Pakistan. Moving on, I believe we have a caller on the line, so I will take this call. Hello, assalamu alaikum.
Hello, alaikum assalam, sister. I've got a quick question.
Yes, brother.
It's regarding British nationality. I've recently applied for a nationality. It's in the process, obviously. It's under 6 months. Did normal during process.
Yes.
The question was particularly, when I applied, my B1 test was due to expire in, I believe, on end of November.
Right.
And I've applied in August. So the particular question is, will that affect, because I applied in August, and when I applied it was still valid, obviously during the time of the application, will that validity point of view is still valid, or will it basically consider to have to take another one, because it will be on, I mean, I'm due to receive my reply probably sooner or later.
Yes.
But obviously the status of the B1, it will be obviously expire.
So
time of
yeah, forgive me, sorry, do carry on.
Yeah, at the time of the application, it was valid, as it was expiring on November, but I've applied in August.
So you applied in August 2021, and then the certificate expired in November of 2021?
Correct.
Right. Thank you so much for that question, brother. So the answer to your question is that the certificate needed to be valid at the date of application, and therefore the fact that it then subsequently expired whilst your application was pending will have little impact on the outcome of your application, because at the date of application you met that requirement and you had a valid certificate and submitted that. So it will not negatively impact on your application. It will still be considered a valid certificate because the relevant date is the date of application.
Fantastic, brilliant. Thanks for your answer.
Absolute pleasure. Thank you so much for your call. Thank you. So for the benefit of our viewers, the brother asked a question in relation to a British nationality application which he has submitted. His concern was this: at the time that he submitted the application, he had a valid English language certificate, which he is required to have at the level B1. He submitted that certificate along with the other supporting evidence. And his concern arose because usually these certificates have a validity of either 2 years, sometimes 3 years. Some of them may be indefinite. But the brother was concerned that his particular certificate expired after a 2-year period, which was around 3 months after he had submitted the application. He is yet to receive a decision from the Home Office in relation to his nationality application, and so his concern is that they may reject the application as the certificate is no longer valid. And as you heard, the answer to the brother's question is that the certificate needed to be valid at the date of application, which would have been in August, and therefore it will have no bearing on his application that the certificate is no longer valid and subsequently expired. The Home Office will still consider that as a valid certificate for the date of application. So alhamdulillah, that brother has his question answered. So moving on to the next question, we have a question. I have recently separated from my husband and I am 6 months pregnant. He was abusive and I am not back at my family home. What right would he have to see the child when it's born if I am not comfortable with this? We are legally married too, but the year of our legal marriage is June. The sister asks again an immigration related and a family law related, well, so forgive me, a family law related question, not an immigration question in this respect. So our sister unfortunately is separated from her husband and an abusive relationship, and she is expecting a child. Her concern is that her husband will seek to have contact with their child once the child is born, but she is not comfortable with this. And her question is, what are her legal rights in respect of preventing her husband from having access to their child? Now, this is a a commonly arising question, unfortunately. And the answer to our sister's question is this. So in terms of parental responsibility, both parents will have that, whether they are together or separate. If your husband seeks to have access to your child, then you can both either mutually agree, and if you do not agree to that contact taking place, then unfortunately you will need to seek redress from the family courts and argue your points before a family court judge. And the judge in those circumstances will be looking at what is in the best interest of your child. It may be that the relationship was abusive, but that abuse is limited to both husband and wife. But there are no safety concerns around the child. And if a judge concludes that, then the judge may grant access to the father to have contact with the child. If there are concerns, safety concerns, then it may be that certain restrictions can be put in place. So supervised contact, for instance, for a period of time so that the father can prove that he is not a risk to the child and there are no risks with this contact taking place. But these are difficult proceedings, naturally. And at that point, the judge is, as I say, tasked with looking at the best interests of the child, not the heightened emotions of each party and whether one parent wants the other parent to have access. But that is your option, I'm afraid. If you can't mutually agree, then it will need to be either a mediation service or the courts that will decide the best outcome, bearing in mind the best interest for the child as to whether or not your child will be safe to have contact with their biological father, which is a human right of both the parent and the child to know their child or parent. We are taking a short break at this juncture. Please join me shortly where I will continue to answer your questions. I do send your questions through in the meantime. Thank you very much. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Thank you for joining me again, and I will continue to take your answers. I believe we have some callers on the line, so I will proceed to take those calls. Hello, assalamu alaikum.
Wa alaikum assalam, sister.
Yes, brother.
Yeah, I got a question. So basically, I have done my biometric on 15th of December last month.
Yes.
Yeah, but I have another letter today, and they're telling me that I have to do the biometric again. So I just want to know what should I do?
If you have received another letter asking you to enrol your biometrics, it may be that your first set of biometrics may have been corrupted. There may have been a problem with them. If you're sure that it's not a duplicate letter, just check the date at the top of the letter. If you're sure that two letters haven't just accidentally been sent out at the same time and received at different occasions, I would suggest that you do go along and then re-enroll your biometrics, because it may be that there was a problem and they do need you to come back and do them again.
Yeah, but I did call them to book my biometric, and they have told me that on our system you have done it your biometric on 15th of December.
Right.
So I don't know what should I do and why they send me another letter.
Yes, I mean, when you...
It must be an error.
Yeah, well, when you spoke to them, did they explain why you've received a second letter?
They told me that we don't know why you do receive that, but they check in their system and they told me that that you have already done your biometric on 15th of December, and nothing is saying that something is wrong on our system, and you've done your fingerprint. So
okay. So in those circumstances, brother, you have two choices. you either have the choice of going along to the second appointment that they've offered you, just to reassure yourself that there wasn't a problem and that you're not required to re-enroll. Alternatively, what you can do is you've spoken to the Home Office and they've explained that maybe you've received the letter in error, in which case you can ignore this letter, make a note of who you have spoken to and when, so you've got an accurate record of what happened and what was said to you. And if the Home Office feels that you do need to re-enroll your biometrics, they may send you a follow-up letter. But if you have made inquiries and they believe that that was sent in error, then you can ignore it if you wish to. I personally, if I was in your position, would suggest that you do go along and just make sure, reassure yourself, because failure to provide biometrics can lead to your application being rejected as invalid. And I would make doubly sure that you are not required to re-enroll your biometrics.
So you are giving the advice that I should go to do the second biometric as well?
Yes.
In case everything goes well.
I would err on the side of caution, and I would go along and try and re-enroll, because there must be a reason why you've had a second letter. And as I say, if you go along and the explanation is that it was an error.
So there is also another problem. You know, that on the two letters,
Yes.
both of them come from different reference number.
Right. And when you spoke to the inquiry line, were they able to explain why that was?
I did spoke with them. The first, when I had the first biometric, and I gave them that reference number.
Yes.
And they are telling me on this reference number, we can see your detail that you have done your fingerprints last month on 15th of December.
And do you only have the one application with the Home Office, or do you have more than one application with the Home Office?
Oh, I have only one application with the Home Office.
Right. Did you submit the application yourself, or did you have assistance from a solicitor?
Oh, from solicitor.
Right. And have you still got that solicitor retained? Are they still instructed on your behalf?
Yeah, he is on my behalf. He's still working on behalf. So he basically, they have sent it to him.
Right.
Environment letter. And he told me that, please, Imtiaz, go to the biometric. They have asked you for the biometric. But I told them I have done it already.
Yes.
So they told me to call the people and tell them that you have done it and process the BRP card to come.
Yes.
You don't need to go.
My brother, you have two solicitors now telling you to go along and just re-enroll your biometrics twice. It's better to be safe than to be sorry later on. Obviously it's your decision, it's your application. You're right, it may simply be an error which can be rectified later on. However, if it's not an error and you are required to re-enroll your biometrics and you fail to do so, it can have a negative impact on your application. So my advice, like your solicitor's advice, is please just go along and re-enroll them. You've got nothing to lose if you do that.
Oh, okay, then I will probably do another one tomorrow. But I did also told them that to come back to me with any inquiry that we have done, ask the Home Office. So they're probably not going to take that long, or do they take long? For
what, my brother? Sorry.
To make the inquiry, if it's the mistake or if it's the right one to do it again.
For your solicitors?
No, I have, the fingerprints people.
Yes.
I called them and I have asked them to do the inquiry.
Yes.
Ask the Home Office if they have making any error, or is it any mistake, or is it they want me to do it again. So they have told me that we will ask them.
Yeah.
So I'm just waiting for them to come to me with the answer.
I don't think they will. I don't think they will. That's not what they're contracted to do. And if they're waiting around for the Home Office to respond, the Home Office may not respond. They may not even make the inquiry. So, as I say, it's your responsibility. It's your application. So rather than trying to rely on somebody else to do things for you, as I say, it's only a case of go along, re-enroll your biometrics, and then resolve the duplication later on, rather than missing an appointment and then having your application rejected.
Okay, then I will probably do that tomorrow. Thank
Wonderful.
you very much.
Thank you very much for your call, brother. Thank you.
Take care. See you. Bye-bye.
Bye-bye. Bye-bye. So in terms of moving on, I will come back and explain what that call was. I believe we have another caller on the line, so inshallah we'll proceed to take that call. Hello, assalamu alaikum. हेलो अस्सलाम वालेकुम।
वालेकुम सलाम। अभी आवाज आ रही है आपको?
जी मुझे आवाज़ आ रही है मेरे भाई जी।
जी मैंने क्वेश्चन ये पूछना था कि मेरी वाइफ और मेरे बच्चे जो है ब्रिटिश हैं,
जी
तो कोरोना की वजह से हम फैमिली जिनके साथ रह रहे थे वो कोरोना की वजह से कौंसल वालों ने हमें इमरजेंसी अकोमोडेशन दिया है।
जी
तो अभी हम इमरजेंसी अकोमोडेशन में रह रहे हैं और अप्रैल में मेरा वीज़ा एक्सटेंड होना है।
अच्छा
तो हम जो है रेंट भी नहीं दे रहे और साथ कौंसल टैक्स भी नहीं दे रहे,
जी
क्योंकि इमरजेंसी अकोमोडेशन की वजह से ये कौंसल वालों को रूल्स हैं कि जो इमरजेंसी अकोमोडेशन में रहते हैं उनको रेंट नहीं देना पड़ता।
जी
तो क्या मेरा वीज़ा एक्सटेंड हो सकता है? मैं फुल टाइम जॉब कर रहा हूँ।
जी मेरे भाई, और आप का इस वक्त कौन सा वीज़ा है?
जी
वीज़ा कौन सा वीज़ा है इस वक्त आपका?
स्पाउस वीज़ा है।
स्पाउस वीज़ा है और ये अप्रैल में रिन्यू होगा।
मैं 2-2.5 साल का था ना, ये अप्रैल में रिन्यू होना है।
जी, और आपने कहा कि आप काम कर रहे हैं, फुल टाइम काम कर रहे हैं?
मैं फुल टाइम जॉब कर रहा हूँ। जी
अच्छा, और मेरे भाई आपकी इनकम जो मिनिमम इनकम लेवल है 18,600 पर ईयर, इससे
उसको मीट करता है।
इसको आप मीट करते हैं। तो आपने कहा कि आप इमरजेंसी अकोमोडेशन में हैं इस वक्त। इमरजेंसी अगर आप काम कर रहे हैं तो इमरजेंसी अकोमोडेशन में क्यों है? आपका प्राइवेटली रेंटेड मिसाल के तौर पर क्यों नहीं है घर?
बेसिकली ये था कि जब मैं आया था कोरोना वो हो गया था ना,
जी
लॉकडाउन,
जी
तो हमारी फैमिली को, फिर मेरे बच्चों को और वाइफ को कौंसिल वालों ने कहा कि आपको 3 बेडरूम मकान देंगे,
जी
लेकिन वक्ती हमारे पास कोई स्टाफ नहीं है, इस तरह का इशू है, तो आप जो है ना इमरजेंसी अकोमोडेशन हमारे पास है, इसमें ठहर जाएं।
अच्छा
तो अभी तक स्टिल उसी में बिल्डिंग कर रहे हैं। तो
ओके
ये है कि जब प्राइवेट चले जाते हैं तो इशू है ये कि बाद में हमें फिर मकान नहीं मिल सकता।
ओके ओके, शुक्रिया मेरे भाई, आप देखते रहे, इंशाल्लाह मैं आपके सवाल का भी जवाब देती हूँ।
जी बहुत शुक्रिया।
Shukriya. Thank you, Mirbait. Okay, so in relation to this question, our brother is asking in respect of his immigration application. He arrived in the United Kingdom with a spouse visa, which is granted usually for a period of 30 months, after which it is then renewed. And our brother will be renewing his leave to remain in April of this year. He is in full-time employment. He meets the financial requirement, which is the 18,600 per annum. However, he is currently on a waiting list for social housing. And due to them waiting and with the situation around the coronavirus pandemic and restrictions, the family are currently provided with emergency accommodation from the council. And his question is can he renew his application in April? Of course, our brother put his question in Urdu, so I will answer in Urdu and then I will translate for the benefit of our viewers who do not understand the Urdu language. So मेरे भाई, आपका क्वेश्चन जो था वो था कि आप अप्रैल में अपनी एक्सटेंशन सबमिट कर सकते हैं या नहीं। तो इसका जवाब है कि आपको एप्लीकेशन सबमिट करनी होगी। अगर आपने एप्लीकेशन सबमिट ना की तो फिर आपका जो वीज़ा है वो एक्सपायर हो जाएगा और फिर आपको यूके छोड़कर जाना होगा या फिर आप ओवरस्टेयर हो जाएंगे। तो ये जो आपकी एक्सटेंशन एप्लीकेशन है ये आपने कम से कम 28 डेज़ अपने वीज़ा ख़त्म होने से पहले आपने सबमिट कर देनी है। दूसरी बात यह है कि आप रूल्स मीट करते हैं कि नहीं, क्योंकि आपका सवाल जनरली यही था कि हम अभी काउंसिल के अकोमोडेशन का इंतज़ार कर रहे हैं, इमरजेंसी अकोमोडेशन हमें मिला हुआ है, तो मैं रिक्वायरमेंट्स मीट करता हूँ या नहीं। तो देखें, रिक्वायरमेंट्स का ये है कि आपका अकोमोडेशन होना चाहिए और जनरली ये भी है कि आपके पब्लिक फंड्स नहीं होने चाहिए, आप पब्लिक फंड्स को एक्सेस नहीं कर सकते, ये आप पर पाबंदी है आपके वीज़े के रूल्स के मुताबिक। तो अगर आप ये कहते हैं कि ऑब्वियसली आपकी वाइफ जो हैं वो ब्रिटिश सिटीज़न हैं, आपके बच्चे जो हैं वो ब्रिटिश सिटीज़न हैं, तो वो पब्लिक फंड्स और सर्विसेज के हकदार हैं अपनी सिटीज़नशिप की वजह से। वो काउंसिल का घर ले सकते हैं, वो काउंसिल की तरफ से बेनिफिट वगैरह ले सकते हैं, पाबंदी सिर्फ आप पर है। सो ये देखना है कि आपको काउंसिल के घर की ज़रूरत क्यों है। इसलिए है क्योंकि आपके वाइफ और बच्चों को ज़रूरत है, या फिर इसलिए है कि आपकी वजह से, क्योंकि आप उस घर में शामिल हुए हैं, इस वजह से उनको एक बड़ा घर लेना है। अगर आपकी वजह से है तो फिर आप अपने कंडीशंस को ब्रीच कर रहे हैं, अगर उनकी वजह से है तो फिर वो उसके हकदार हैं। दूसरी ये बात है कि अगर आपकी आमदन है और इस लेवल पर है कि आप अपना घर ले सकते हैं तो फिर इंतज़ार करने का मकसद नहीं है। देखें, आप अपनी रिस्पॉन्सिबिलिटी खुद लें। सोशल सिस्टम वहाँ है उन लोगों के लिए जो मजबूरी से उसको सपोर्ट चाहिए। तो आप एप्लीकेशन प्लीज़ डालें, क्योंकि उसके बावजूद अगर आप नहीं डालेंगे तो वो आप ओवरस्टेयर हो जाएंगे, आपकी फिर आपको कोई हक नहीं है। आप इस ब्रेक के बाद वापस आएँ तो इंशाल्लाह मैं आपका सवाल जो है वो ब्रेक के बाद मुकम्मल करती हूँ। शुक्रिया, थैंक यू वेरी मच। Assalamu alaikum and welcome back to the Free Legal Advice Show. I am your host, Riffat Hussain. Just before we went to our brief break, I was taking a question from our brother in relation to an extension application that he needs to make in April of this year. I was responding to our brother in the Urdu language just to help him understand a little bit more clearly the guidance that he requires, and then I will translate for the purposes of our viewers who do not understand the Urdu language. So मेरे भाई मैं आपका सवाल कंप्लीट करती हूँ। तो जैसे मैंने कहा था ब्रेक से पहले कि आपने एप्लीकेशन एक्सटेंशन वो डालनी है। अगर आप नहीं डालेंगे तो फिर आप ओवरस्टेयर हो जाएंगे, और अगर आप ओवरस्टेयर हो जाते हैं तो या फिर आपने यूके छोड़कर जाना है या फिर कोई और एप्लीकेशन डालनी है। लेकिन अगर आप अपने वीज़े के बाद एक्सपायर होने के बाद वो एप्लीकेशन डालते हैं तो आपके जो राइट्स हैं, मिसाल के तौर पर आपका जो हक है काम करने का, आपको वो जो इजाज़त है वो ख़त्म हो जाएगी। पब्लिक फंड्स की इजाज़त पहले नहीं है आपको, लेकिन पब्लिक सर्विसेज जो आप एक्सेस कर सकते हैं, हेल्थ केयर वगैरह, उसका भी आप पर रिस्ट्रिक्शन हो जाएगा, यानी कि वो भी आप एक्सेस नहीं कर पाएंगे। और जब तक होम ऑफिस फिर आपकी नेक्स्ट एप्लीकेशन का डिसीजन नहीं लेती है उस वक्त तक आप फिर ओवरस्टेयर की हैसियत से यहाँ रहेंगे और ज़्यादा पाबंदी होगी आप पर। तो ये है कि अगर आप ये एप्लीकेशन डालते हैं और आप ये कोई भी रिक्वायरमेंट्स मीट नहीं करते तो जो अपेंडिक्स FM है जिसके अंदर आप ये एप्लीकेशन डालेंगे उसमें एक एक्सेप्शन का प्रोविज़न है। एक्सेप्शन ये है कि अगर आपके यहाँ ब्रिटिश बच्चे हैं, आपकी यहाँ ब्रिटिश वाइफ है और आपका यहाँ से जानना आपके लिए डिफ़िकल्ट होगा उनको साथ लेकर, तो फिर होम ऑफिस जो है वो एक्सेप्शनल बेसिस पर भी आपकी एप्लीकेशन जो है वो कंसिडर कर सकता है। तो आप उस पर रिलाई कर सकते हैं अगर कोई एस्पेक्ट आपका एप्लीकेशन का मीट नहीं करता रिक्वायरमेंट्स को। लेकिन आप एप्लीकेशन की डेडलाइन मिस ना करें क्योंकि इससे आप पर ज़्यादा प्रॉब्लम पेश आएंगे। नेक्स्ट ये चीज़ है कि आप किसी से मशवरा करें। पहले आप अपने सर्कमस्टांसेस को किसी को दिखाएं, अपने पेपर्स किसी लोकल वकील को दिखाएं और उनसे मशवरा करें कि आपके लिए बेस्ट ऑप्शन कौन सी होगी, क्योंकि सही एप्लीकेशन राइट टाइम पर डालना ये भी आपके लिए बहुत ज़रूरी है। अगर आप रॉन्ग एप्लीकेशन डालते हैं बाद में वो रिजेक्ट हो जाती है तो फिर आपकी डेडलाइन मिस हो सकती है, दोबारा वो प्रॉब्लम आ जाती है कि आप ओवरस्टेयर हैं जब तक आपकी नेक्स्ट एप्लीकेशन कंसिडर होती है। और ये भी है कि जो 2.5 years आपने यहाँ लॉफली गुजारे हैं वो भी टाइम आपका जो है वो ज़ाया हो जाता है। So just coming back to translating the information I have provided. So I advised our brother that he must still submit his application before his deadline in April of this year. Failure to do so will result in him becoming an overstayer in the United Kingdom. It will then mean that he is prevented from working. He is also prevented from accessing public funds. He's already prohibited from accessing public funds. He will be prohibited from accessing public services such as healthcare and so forth. I also advised our brother that if there are certain aspects of the immigration rules that he doesn't meet at the time of the application, then under Appendix FM of the immigration rules, which is the relevant section here, there is a provision of exceptional applications which can be considered also where certain aspects of the immigration rules can be waived. Particularly the financial requirement and the English language requirement, but the wider aspects of the application will be looked at. And so the brother may feel that he needs to fall back on those provisions, but he is again advised to get specific advice around his circumstances from a local solicitor so that he can fully understand the correct application and the supporting documents prior to making that application, not once it's gone wrong and he's then trying to remedy the problems that have arisen. Moving on, we have another caller on the line, so I will proceed to take that call. Hello, assalamu alaikum.
Hello, assalamu alaikum.
Yes, wa alaikum assalam.
Can I talk in Urdu?
Yes, please do.
जी मेरा एक क्वेश्चन था वो ये कि मैं और मेरा बेटा रेफ्यूजी वीज़े पे हैं
जी
और वो मेरा डिपेंडेंट है
जी
तो क्या ऐसा कोई लॉ या क्लॉ है जिसकी वजह से अगर मैं पेरेंट रेफ्यूजी वीज़ा पे हो तो जो बच्चा है उसको इंडेफिनिट मिल सकता है
So, इस वक्त आप दोनों रेफ्यूजी वीज़ा पर हैं
सॉरी
इस वक्त आप दोनों के पास रेफ्यूजी स्टेटस है
जी
और आपके बेटे की एज क्या है
मेरा बेटा माशाल्लाह 6.5 साल का है
अल्हम्दुलिल्लाह ओके और आप ये जानना चाहते हैं कि आप रेफ्यूजी स्टेटस पर रहें लेकिन कोई तरीका है कि आपके बेटे को इंडेफिनिट लीव टू रिमेन मिल जाए
जी
ओके मेरी बहन ऐसा कोई प्रोविजन नहीं है आपकी रेफ्यूजी लीव कब एक्सपायर होगी आपके 5 इयर्स कंप्लीट कब होंगे
नेक्स्ट ईयर मई में
नेक्स्ट ईयर मई में ओके सो ऐसा कोई प्रोविजन नहीं है कि आपके बेटे को आपसे पहले इंडेफिनिट लीव टू रिमेन मिले तो आपका ये होगा कि आप दोनों इंडेफिनिट लीव टू रिमेन टुगेदर अप्लाई करेंगे नेक्स्ट ईयर इंशाल्लाह और फिर आप दोनों को इंडेफिनिट लीव टू रिमेन मिल सकता है उस वक्त
लेकिन ऐसा नहीं होगा कि मुझे जब इंडेफिनिट मिलेगा तो उसको ब्रिटिश पासपोर्ट मिल जाएगा
ये एप्लीकेशन आप डाल सकते हैं अगर आप इंडेफिनिट लीव टू रिमेन आपको मिल जाए और आप अपने बेटे के लिए ब्रिटिश सिटीजनशिप अप्लाई करना चाह रहे हैं तो दो तरीके हैं एक ये है कि आप उसको अपनी एप्लीकेशन पर डिपेंडेंट करें और उसका आपके साथ उसका इंडेफिनिट लीव टू रिमेन उसको मिल जाएगा और फिर आप उसके बाद उसकी इंडेफिनिट लीव ब्रिटिश सिटीजनशिप की एप्लीकेशन डाल सकते हैं दूसरा तरीका ये है कि आप अपनी इंडेफिनिट लीव टू रिमेन अप्लाई करें और फिर बाद में बेटे के लिए आप ब्रिटिश सिटीजनशिप की एप्लीकेशन डालें लेकिन मेरी बहन ये ज़रूर समझें कि इसमें रिस्क है आपके लिए क्योंकि अगर आप अपनी एप्लीकेशन डाल देते हैं आपको इंडेफिनिट लीव मिल जाती है और ऑब्वियसली इसमें टाइम लगेगा एप्लीकेशन डालने में और डिसीजन आने में कम से कम 6 मंथ्स इस वक्त अभी ज़्यादा भी लग रहे हैं उस दौरान फिर आपके बेटे की स्टेटस क्या है क्योंकि वो देखें अभी वो अगर डिपेंडेंट है तो वो रेफ्यूजी है अगर आप उसको अपनी एप्लीकेशन के ऊपर नहीं डालते हैं तो फिर उसका तो वीज़ा ख़त्म हो गया तो उसके लिए फिर प्रॉब्लम आ सकते हैं मिसाल के तौर पर ऑब्वियसली वो स्कूल में है तो फिर स्कूल का क्या होगा अगर उसकी स्टेटस नहीं है अगर अल्लाह ना करें उसको कोई मेडिकल ट्रीटमेंट की ज़रूरत हो उसकी स्टेटस नहीं है तो फिर आपको उसकी फ़ीस भी देनी पड़ सकती है तो ये सोच समझ कर डालें क्योंकि ये है ऑप्शन आपके लिए बेटर ये है कि आप उसके लिए अपने साथ इंडेफिनिट लीव टू रिमेन अप्लाई करें जब दोनों को वो मिल जाता है तो फिर उसके बाद जो है बेटे की ब्रिटिश सिटीजनशिप के लिए आप अप्लाई कर सकते हैं
बहुत बहुत शुक्रिया
ओके शुक्रिया मेरी बहन
थैंक यू
Allah Hafiz. Our sister was asking a question around her refugee status. So currently she has refugee status in the United Kingdom and she has a dependent child who is 6.5 years old. Her question was whether there are any provisions which allow for her to apply for her child's indefinite leave to remain early. Both of them will apply for their indefinite leave to remain upon the expiry of their visa next year. I explained that there are no such provisions which allow for early indefinite leave to remain for a dependent child on a refugee application. The sister asked whether she could apply for citizenship, British citizenship for her child, and I explained that she can do. There are 2 ways of doing this. There is the option of applying for citizenship for the child and indefinite leave for the parent, but that carries its own risk. And the risk is this, that until the parent has indefinite leave to remain, it's difficult to establish a citizenship entitlement for the child, even on a discretionary basis, particularly a child of that age. And therefore, it's likely to be rejected. The other way of doing it is for the parent to apply for their indefinite leave to remain, but not include the child as a dependent. Now, that is extremely risky because what that essentially means is the child no longer has status in the United Kingdom. Certainly not until the parent has acquired their indefinite leave to remain and then made an application for citizenship for the child to be registered. And that is an application that one would certainly not advise, or certainly a route one would not advise to be taken, because there are inherent difficulties with a child who doesn't have status, namely what happens to their schooling entitlement, what happens if your child is needing medical care. Most hospitals will then charge for providing medical care because, unless it's emergency care, because the child no longer has status in the UK and is therefore no longer entitled to the free medical help that would otherwise come with their status. And so the advice usually is apply for the indefinite leave to remain for all of the dependents, parents and dependents, and then consider any registration applications thereafter. And that's the most safest route to take. And the advantage with applying for indefinite leave to remain as a refugee is that there are no fees. There's no application fee. It's a free of cost application. It's a more simpler application than under most other routes. And so you really do need to take advantage of that and secure yourself and your child with the permanent status in the UK before considering further applications that need to be made. But thank you, Sister, for that question. And I hope that clarifies the position for anybody else who may be considering a similar route to take. Another question from our sister. She says, Assalamu alaikum, alaikum assalam. I would like to ask that if a postgraduate student wants to get married with a British spouse here in the UK, like they want to go for a court marriage and also the Islamic nikah, do they have to get permission from the Home Office? Please let us know. Jazakallah khair. Barakallah feek. Sister, in terms of your question, so it relates to an individual who has a graduate visa in the United Kingdom and they are seeking to marry a British citizen, both in terms of an Islamic marriage and then also to have a registration of that marriage in the UK courts. So with regards to the question specifically about permission, there are a number of things that need to be taken into consideration when a migrant is wanting to seek marriage in the United Kingdom. Inshallah, I will come to those considerations. We are approaching a short break. I will come to your answer after that break. Before I do proceed to that break, can I remind everybody that we are now coming to the last segment of this show. Please do send your questions through so that I can get through them. And inshallah, I will be back just on the other side of this break with the answer to this particular question. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. We have now entered the final segment of this show, and inshallah I will continue to answer as many questions as I am able to get through. Just before we went to that break, a sister presented a question in relation to marriage options in the United Kingdom for an individual who is lawfully here on a graduate visa. Before I do address that sister's question, I believe we have a caller on the line, so inshallah I will take that call first. Assalamu alaikum.
Wa alaikum salam, sister.
Yes, brother, please go ahead.
Yeah, first of all, I would like to congratulate you for the good show that you're doing.
Thank you.
This is the first time, actually, that I watch it. Sister, I've got two questions, if I may.
Please.
Yeah, basically, well, I've had, me and my wife had, let's say, indefinite leave status in 2006.
Yes.
And 3 of our children were born, let's say, before that.
Right.
Which meant that the two that were born after that had the automatic registration for citizenship.
Yes.
But the other three, we applied later on, let's say, basically last, I believe in 2019, for indefinite leave for three of them as under 18 years old.
Right.
Yeah. What happened is we made the application through a solicitor, and we paid the fees and everything.
Right.
And then at a certain point, the government dropped the fees. So they allowed, let's say, whoever paid the fees for indefinite leave for children to claim their fees back.
Right.
All right. So, and basically Brexit after that came, and the whole situation changed. So settled status replaced, let's say, indefinite leave or permanent residency. So the solicitor claimed the fee back, but we've never received it.
Okay.
So I just would like to know if there is any way to chase the Home Office about those fees that we paid. That's the first question.
Sure.
So can I ask the second one?
Yes, please ask both together and then I'll address them together for you.
Yes. So the second question is, after they had all three of them the indefinite leave or settled status,
yes,
we applied for them to get registered for British citizenship as under 18. The first child, two of them had already the certificate of citizenship, but the first that applied for from June 2019, he still haven't had the reply, let's say.
Right.
And instead of that, we received a letter on November asking us to pay a fee for the ceremony.
Okay.
Because they say because the child reached 18 years old.
Yes.
While the application is in process.
Yes.
So is that legitimate? Is that okay? Because, as I said, we applied before he reached 18, let's say.
Yes. So continue to listen to the show, brother, and I'll answer both of your questions together, inshallah, and hopefully that will give you sufficient guidance to move forward.
Inshallah. Just the last thing.
Sure.
Sorry, I know my questions are very long.
Not at all.
Sorry about that. Yeah, I mean, just because we applied in June 2021.
Yes.
And still, till now, we haven't received, let's say, a reply. Is that normal?
That is at the moment normal, I'm afraid, yes.
Okay.
Okay. And thank you so much. Thank you, brother. I will address your questions. Thank you.
Thank you so much. Thank you for the show.
Thank you. So our brother asks quite poignant questions here because at the moment the system is in a very chaotic stage. We have a lot of delays within the system, the immigration system, that is. A lot of applications are taking extremely lengthy periods of time to be considered. There are actions that would normally be relatively straightforward, but they're time-consuming or they're just not materialising. Our brother had two main questions. The situation is this, that the family had indefinite leave to remain since 2006. Now, the thing with indefinite leave to remain is that any children that are born to a parent who has indefinite leave to remain, either settled status through the European route or indefinite leave to remain through the immigration rules, that's the difference. The language difference is there. Both of them mean the same thing, permanent residence in the United Kingdom. If it's acquired through the UK immigration rules, is generally referred to as indefinite leave to remain. If it's acquired through the European regulations, then it's now known as settled status. It was previously known as permanent residence. In 2006, our brother and his wife acquired their permanent residence in the United Kingdom. They already had 3 children prior to acquiring their status. 2 children were born after. With the two children who were born after, Because our brother and his wife already had settled status, under nationality legislation, they are automatically British citizens. So there were no questions in respect of those two children. With regards to the three children who didn't have the indefinite leave to remain, they have since now registered for their permanent residence or settled status. And there was a period of time where the Home Office was charging a fee for that, and later on that changed and the fee was no longer payable. Our brother's question is this, that his solicitor has applied for a refund and that refund has not materialised. My answer to that question, my brother, is that you do really need to make inquiries with your solicitor. Is it a case that the refund was owed and it's just got lost in the system, that your solicitor would then need to write back to the relevant team at the European Resolution Centre, and they would need to request that information back. You can also contact the Resolution Centre by telephone and make that inquiry yourself, but also check whether there is in fact a refund due. It may be that there was a cut-off period, and therefore you're not entitled to that. So those are the inquiries I would make with your solicitor, or contact the EU Resolution Centre directly. If you search EU Resolution Centre, their number is widely available. They're not the easiest department to get through to, but at least you can speak to a human being, unlike most other Home Office departments. The next question related to registration as British citizens. Our brother made the application for his children whilst they are all under 18. Children who are under 18 are automatically issued with their citizenship certificate. They do not need to attend a ceremony, unlike adults, to receive that. Our brother has received notification that because his child will now be turning 18, he needs to pay the additional £80 ceremony fee so that his child can attend the ceremony and receive his or her certificate at this ceremony. And our brother wanted to know whether that position is correct, and the answer is yes. If an application is pending and in the meantime the child turns 18 years of age, they are then required to attend a ceremony. You are then required to pay the £80 ceremony fee, and so you will need to pay that for the application to proceed. Our brother said it was the first time he was watching our show, so Jazakallah khair for doing so, and inshallah, hopefully we've been able to help you, and you will continue to watch our show in the future. That answers our brother's question. Before we took our brother's question, we were going through some other questions that we had received, and we have a question here from a sister. Assalamu alaikum, wa alaikum assalam wa rahmatullah. I want to ask a question. Please respond. My 20 years base application was submitted to the Home Office 9 months ago, and 10 months is going to be in December. Sorry, now we're in the 10th month. In December, the Home Office asked for a valid passport within 10 working days, which I did before the deadline. I haven't heard back anything from the Home Office yet. Please let me know how we can chase them with regards to a decision, as it's already 10 months going on. I am so worried about it, how long they are taking in these types of applications to decide. I submitted all 21 years worth of evidence along all requirements. They only asked for the passport. Jazakallah khair for your question, sister. Now, our sister submitted a question, submitted an application even, after residing in the United Kingdom for 20 years. And there are specific rules relating to this within the Home Office immigration rules. She was then asked to provide a valid passport. And again, that is a requirement of the immigration rules with any application submitted. A valid passport must be submitted. or an explanation as to why it is not within the control of the applicant to provide a valid passport. Our sister was asked to provide that, and she's concerned at the length of time this application is taking. Please don't be alarmed. This is fairly common. 10 months delay, you're still winning, I would say, because at the moment these applications are taking anything between 9 to 12 months, and now some are taking more than 12 months. But the fact that the Home Office have contacted you, they have asked you for further evidence, is indicative of the fact that they are actually dealing with your application. There isn't anything else outstanding. So inshallah, I would expect a decision within the next couple of months. How can you chase them? There should be a letter on the top of, there should be an address even on top of the letter that you receive from the Home Office advising you which department is dealing with it. You can write to them for an update. I would personally suggest that you give them about 4 weeks before you do that, and then seek an update after that point. But please don't be alarmed. This is fairly common, and this type of delay is. We are now approaching the end of this show, and I do thank you all for participating, for watching, for sending your questions through, and my deepest apologies for those whose questions I haven't got around to answering. Inshallah, I am back in several weeks' time. Join me then. And Jazakallah khair for joining me today. Assalamu alaikum wa rahmatullahi wa barakatuh.